Okay, good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I'm Eric Eisnagel. To my left, we have Judge Harris, and to my right, we have Judge Grosshans. Please remember to turn off any cell phones, electronic devices you have, or put them on silent so we don't interrupt the advocates. Our first case today is 18-1300, Wyman versus Duke Energy. And if the, if the appellant, when you get up, if you could just tell me how much time you'd like for a rebuttal. And with that, we are ready to proceed whenever you are, counsel.
Thank you.
5 minutes?
5 minutes would be perfect, Your Honor. May it please the Court. My name is Nick Shanine, and for this oral argument, I am representing the appellant, TYSON WYMAN. This case is not a complex case. It is a very straightforward, really a single-issue appeal, and it's all about one thing: the inconsistent verdict that the jury provided, the immediate and proper objection to that inconsistent verdict while the jury was still impaneled, giving the judge the opportunity to have that error fixed, the judge's refusal to do so, and then subsequent refusal to take an alternative step of either added or a new trial, places us in this position where we are today. It would have been best to have had the jury fix the issue on the spot when it had the opportunity to do so while they were impaneled after the trial, but unfortunately that did not occur.
Is it reasonable to conclude that the jury could have found the only damages were to the torso, the scratches or the scrapes or the bruises? Those were the damages the jury determined?
Well, it's not reasonable to determine that for two reasons. One is the incontroverted medical evidence was all that the wrist was in fact broken. So when you have this question answered with the check mark yes, was there any negligence on the part of the defendant, Duke Energy Florida, which was a legal cause of damage to the plaintiff? And here the legal cause of damage was the wrist. The torso bruising was not a feature of the case.
Well, counsel, they had, I think everybody agreed below that the wrist was broken, correct? That was undisputed.
That was undisputed.
What was disputed is causation, though, correct?
Absolutely. That was the hot button issue for this case. The defense tried to claim that somehow Mr. Wyman had been walking around this earth with a broken wrist and never had to have it worked on, and then this fall happened.
Was there substantial competent evidence from which the jury could have concluded that while the wrist was broken, that it was not caused by Duke Energy's employee?
I will say this, had they rendered that verdict, I would have probably received a call from the plaintiff's counsel asking if I could appeal it, and I would have declined for exactly that reason. That there would have been enough evidence to support a jury verdict if they had checked that box, no. But they didn't check that box, no. They checked that box, yes. And then they went on and checked the next box, yes. And then they went on and actually did their job to apportion liability, saying my client was 60% at fault. The case law that supports the fact that this is an inconsistent verdict, that you can't have a zero verdict for damages even where you have a contributory or comparative negligence finding, has often worse numbers than 40-60. That there's an 87-13 case that we've cited where even if the plaintiff is only the defendant rather is only 13% at fault, checking that box yes means that they were contributing to the legal negligence.
Well, it could be 99-100, right? Or 99-1%, right?
That is correct.
Not 99-100, but 99-1%. But I think that before we even get there, the question, though, is the first question that the jury answered. It seems to me that's the focal point here. What evidence of damages was presented below, right? There was the wrist. The broken wrist was presented to the jury.
Sure.
What else?
Well, first of all, there were 5 doctors who testified, and every one of them said that the wrist was broken or had no opinion on the subject. But he himself testified. All the medical records were introduced without objection.
No. Probably my question was inartful. Let's assume for a minute that there was plenty of evidence on the broken wrist, and so there's clearly evidence presented to the jury that the wrist is broken.
Sure.
What other evidence of damages other than the broken wrist was presented to the jury?
That was the focus of this case. The broken wrist resulting from the fact that as he's talking with this gentleman, the gentleman decides to hit
But it
the
wasn't
hit
the
gas and
only
pull away.
evidence
Well,
of
no,
damage.
he did have photographs showing that his torso was bruised, and that was very relevant to show that the impact from the defendant's vehicle speeding away unexpectedly for the plaintiff was enough to cause him to fall, to bruise and get scraped. That was no one sues over that. Well, it's possible that someone would sue, but that's not what this case was about. The evidence about the pain, damages, suffering, medical circumstances, surgery, potential for future surgery that he declined.
At any point, was the jury told that the appellant did not want damages for anything other than the wrist?
And to be fair, the damages or the pain and suffering that comes with being thrown to the ground could certainly be added in by the jury. They could augment the wrist, but the wrist was the thing. And it would be an unfortunate and egregious miscarriage of justice, in my opinion, to ignore the elephant and focus on the flea on the elephant.
Well, counsel, what if the jury didn't believe your client's case as to the wrist?
If they hadn't believed
But
our
they
client's
did
case,
believe your client's case as to the bruises and the scraping.
if that was really going to be what the defendant wanted to have shown here, a better verdict form should have been proposed by them. This verdict form...
Why is that their duty?
Well, it's everyone's duty to have a proper verdict form, but this verdict form was agreed to by the parties, and it simply says, was there any negligence on the part of them, which was a legal cause of damage? And if you're going to have legal cause of damage, incidental damage, which might not be a legal cause of damage, shouldn't be enough to get the jury to check that box. Yes, no one argued that to them. In fact, to the opposite, the defense counsel specifically told the jury that no one's telling you there is no fracture in that wrist. No one has said, except for Dr. Choksky, who missed reading it on the x-ray. Dr. Halperin told you there was a fracture. Dr. Chichi agrees there was a fracture. This is defense counsel saying this. The question really is when. When was this wrist fractured? That was the focus of the case. Everything in this case was about the elephant. No one argued that you should award damages for a bruise, or you should award damages for this.
Did someone need to argue that to the jury? Presenting the evidence to them isn't enough?
Well, only if we're going to ignore what was actually the primary thrust of the jury in order to create a very obscure way to make this sentence make any sense in relation to the sentence that follows.
Say that the wrist was the trial.
The wrist was the trial.
Maybe I'm reading it wrong or remembering it wrong, but I don't think wrist is mentioned one time in the complaint. The broken wrist is not mentioned one time in the pretrial statement. Opening statement, it's argued, hurt his neck, hurt his back, hurt his torso. Albeit the back, there were scratches on the back, I think, but those are the three things argued in opening. Why can't the jury focus on the torso? Say, okay, they proved that those damages were caused. They didn't prove any damages, no monetary damages because of the scrape, so we find Duke was at fault, 40%, but they didn't prove any damages to the torso, 0.
Admitted, complaints are supposed to be plain, simple statements of the facts, and they don't normally detail specific medical injuries, and for a reason, that you don't want to pigeonhole your case when you file your complaint. The opening statement was talking about the general nature of the injury and the way it happened, and yes, he did talk about the neck and the back. That's all absolutely true, Your Honor, but all of the medical testimony, all of the damages testimony was focused on the wrist. And if this court is going to allow for this type of inconsistent verdict to stand without telling trial judges, taking this opportunity to clear what is still to this day ambiguous case law on whether or not a contemporaneous objection is required for preservation of an inconsistent verdict. This court has mused, Judge, I forget the name of the concurring judge, but there was a specific opinion.
Altenburg.
Altenburg is definitely the one who came up with the concurrence in Cohen versus Thornton, and that concurrence was adopted by this court in Simpson versus Stone, verbatim, lengthily, and there's a reason for it. It's correct. I stand with Judge Altenburg and believe that it is important to require to preserve an error for inconsistent verdict, that you give the jury the opportunity to fix the error when it's there. This case presents a clean opportunity for this court to set that rule and make it clear that we do need that objection to be made. And because it was made and the judge refused to do so, we'll never know what the jury would have done with given the opportunity to fix this error. But the error is here.
What would they have had to do, counsel? Would they have had to redraft the verdict form for the jury to fix it?
I am not certain about how that works. I've seen the case law discuss in other instances where the judge did have the jury go back.
You're asking us to, instruct the trial courts in how to handle this. So what is the way that they would handle it?
I believe most trial counsel at this point in day and age, they have their computer set up. They should have extra blank verdict forms where they could provide a new verdict form for the court. The court often has it on a doc, PDF or doc to print out a new verdict form. But even if they didn't, certainly you could take the form you have, scribble on the answer that was inconsistent with the other, whichever way the jury wants to go with that.
Counsel, how is it, just conceptually, how is it an inconsistent verdict if you must revise the verdict form in order to clarify?
Okay, well, and again, you don't have to revise the form itself. The form is fine. It's what they answered to the form. Either.
Well, no, I guess if that's the case, then I'm just not seeing how it's an inconsistent verdict, because it seems to me, I don't understand why the jury couldn't have concluded that the bruises and scrapes that were presented to them and argued to them, and at least in opening, were damage. In theory, your client could have asked for nominal damages for that, right, at minimum.
If the jury had resulted in that belief that we don't believe the wrist at all, and yet we're still marking this box yes, then it means that they believed that the torso and the bruising was damage, and therefore they should have put some number here to represent that. If they had put $100.
Well, wait a minute. Where should they have put it?
They could have. What is the total amount?
There's number 4 is medical expenses. There were no medical expenses for the scraping.
For the scraping and the bruising. But number 5, what is the total amount of his pain and suffering, disability, physical impairment, disfigurement, mental anguish, inconvenience, all of these things? Certainly, if you are going to check that box yes, they had to go to at least box 5, say $1,000, $100.
But put
Where did
$1.
they get that number from?
That's what the jury does.
No evidence presented on that issue.
Well, but there was evidence presented in general, as Your Honor pointed out, that there was the photographs of the bruising. There was the testimony of the bruising. So there was evidence. There was no quantification. There was no argument to the jury as to
So
its
if you
worth,
wanted
this
nominal
number.
damages for the scrapes, why didn't anybody argue that?
Because
to the trial
nobody
court?
did want that. But if a jury is going to find it anyway, the jury needs to put a dollar
But
on
after the verdict came back, if you had said to the trial judge, clearly this is incorrect, we at least get nominal damages for the bruises and scrapes, right? Then perhaps you'd have a case, but nobody argued that to the trial judge.
Judge, if I'm understanding your question, you're saying that not only did my client's attorney need to object timely to the inconsistent verdict, but he needed to phrase his request to the court in such a way that it could have encompassed this relatively minuscule possibility, the flea on the elephant, instead of going, Judge, this doesn't make sense. These two answers are inconsistent with one another. Preservation doesn't require that bridge.
You have to put the trial judge on notice of the specific argument, correct?
That is what I'm arguing here. Now, some of the case law doesn't agree. Some of the case law says, look, you don't need a contemporaneous objection because in this instance, the inconsistent verdict is also an inadequate verdict. And because inadequate verdicts are preserved simply by filing a timely motion for added or a new trial, you don't need the inconsistent verdict. I'm with Judge Altenberg. I believe that you do need a contemporaneous objection. I am not, however, willing to say that not only do you need that, but that contemporaneous objection needs to detail every possibility that the jury...
Your client's contemporaneous objection was focused solely on the wrist. It was not focused at all on nominal damages for the scrapes. You agree?
I don't disagree with that. And I think that is not a proper reason not to grant a reversal in this case. Trial judges should send these inconsistent verdicts back when you have a check mark yes and a 0, or a check mark no and a number. Those are the classic inconsistent verdicts that require the jury to get its chance to fix it then. And I request this court to consider this case as a proper vehicle for getting that rule across to simplify what goes on at the trial court level and then what we do here, and maybe have fewer appeals as a result. I see I'm getting close to my rebuttal time, so I will return for that. Thank you, Your Honor.
Thank you, counsel. Good morning, counsel.
Good morning, Your Honor. May it please the court. My name is Ramon Vasquez. Here with me at the table is Ms. Catherine Christian. She is Associate General Counsel for Duke Energy. We represent Duke Energy, of course. Your Honor, we respectfully submit that the trial court did not abuse its discretion when it denied the motion for editor and motion for new trial. I believe that Judge Harris hit the nail on the head when he pointed out to the appellant's counsel that the issue that was presented by the jury to the jury during opening arguments would have been neck, back, and chest injuries. However, that was not what was ultimately argued. That's not the focus of this appeal, but rather now all of a sudden it's the wrist injury. We have 3 points that we want to make. There was definitely an altercation between the two men. That is undisputed. There was some kind of altercation. The facts vary depending on who do you believe. The jury heard both factual versions. One by Mr. Wyman when he came out in shorts, shirtless, because he was taking a shower, and all of a sudden his power was disconnected. He said that it had happened in the past, and it was a custom to extend him the courtesy of a few hours so he could pay his bill. As it turned out during trial, that was not the case. It had only happened once. It wasn't a custom. It was just a one-time.
Counsel, we're certainly familiar with the
Yes.
facts. We've read the briefs. I guess what I'm curious about is, your opposing counsel, does raise an interesting point. How does the answer to question 1, where the jury very clearly says that Duke Energy, through its employee, was the legal cause of damage to the plaintiff, and then question 4 and 5, really, where the total amount of damages is 0.
Yes, Your Honor, and as we have pointed out in the brief, the jury heard testimony from everyone. And regarding the wrist injury in particular, there was live testimony from the defendant's expert, an orthopedic surgeon, Dr. Halperin, who testified that it was a non-union fraction. It was powerful testimony that actually relied on the surgeon's medical records regarding the non-union fracture. It was undisputed that there was not a fresh fracture. That's what the jury heard. The jury also heard...
Specifically testified it could have happened when the appellant was 15 or 25.
That is correct,
I think
Your
that's
Honor.
almost an exact quote. But so clearly there was evidence from which the jury could have decided that Duke Energy did not cause the fracture to the wrist.
That is correct, Your Honor.
So how do you explain then the jury's answer that yes, Duke Energy was the legal cause of damage, but awarded 0?
Mr. Wyman chose to present to the jury the injuries to his torso, which he describes as scrapes and bruises. Not only that, 30 minutes after the incident, he chose to take a picture, which was submitted into evidence. So it's part of the record evidence, which the jury saw. When asked specifically, why didn't he take that picture, the question was, so you're saying it's swollen the backside of your wrist so we can't see it in the photo. It's swollen all the way around. No, you can't see it. So he concedes that you cannot see the wrist injury. So this picture shows us a swollen wrist. That's not what the picture is for. No, it's to show bruising and scrapes. So if he believed that he wanted to present a wrist injury to the jury, he's the one who chose to take that picture. He didn't take a picture of a swollen wrist. He didn't treat for those scrapes and bruises at all. There was no medical record for treatment for that. The first time he treats is 13 days after the incident, when an X-ray is taken, and that X-ray, at first...
Counsel, the scrapes and bruises were damages, right? Now that's evidence of damages, correct?
Yes, they are. And
shouldn't the jury have at least awarded nominal if the scrapes and bruises are what the jury said was the legal cause of damage? If that's the damage the jury was focused on, shouldn't they have awarded at least nominal damages?
That was not the focus of plaintiff's counsel's objection at the time while the jury was still impaneled. It wasn't even brought to the court's attention at the time to award nominal
You're saying
damages.
it wasn't preserved, but that doesn't answer the question of should the jury have awarded at least nominal damages? Preservation aside.
Yes, we respectfully submit that no, because there was no treatment. It did not require anything other than time
Nominal
for it to
damages
heal.
require treatment?
Not necessarily, Your Honor, but I understand the court's position, and if the court is so inclined, then we would submit that would be an issue for editor, limited to nominal damages on those scrapes and bruises, if that's the case. To the extent that they're trying to present a new trial, we believe that the jury's verdict is pretty much sacrosanct. It should not be mingled with unless there was a clear manifest injustice. And in this case, there were not mutually exclusive issues. They could have said, yes, there's a legal cause for those scrapes and bruises, but zero damages because there was no treatment, no medical records for those scrapes and bruises. We don't believe that the wrist injury is related to this incident at all.
We just don't know. We don't know what the jury found, right? I mean, as far as we don't know what we don't know if the jury said that there was damage for legal cause for the damage for the bruises, for the wrist, for that. We just don't know.
Well, that is correct, Your Honor. Had the verdict form been more detailed, special interrogatories with the verdict form, then perhaps we would know.
What if the verdict form had said, Duke Energy was the legal cause of damage to plaintiff's wrist, yes or no? And they had said yes.
Then it would be a different scenario.
Well, and then they ordered $0 in damages. Would we be reversing then?
Yes, Your Honor. Yes, Your Honor, but that is not what the jury verdict says. And of course, it was... What
if appellant had offered no evidence of damages at all except for the wrist? Didn't offer any testimony or evidence related to the neck, offered no testimony or evidence related to damages to bruises to the torso. The only evidence presented to the jury would have been the wrist. And the jury said yes to this question, number one, as written. Would we have a reversal?
Yes, Your Honor. That is a different factual scenario, though. That is not what the jury saw. That is not what the jury considered. So we have a complete different case from Cowan versus Thornton and the other case law cited. In neither one of those cases, I cannot find any of those cases where it says that other damages were considered by the jury. However, they disregarded those damages. In this case, there were other damages that the plaintiff himself chose to present to the jury, and he chose not to pursue those damages when he still had the time while the jury was impaneled.
Whose responsibility do you think it was to have a clear verdict form if it seems that is the issue?
I would submit that would be the plaintiff because he is the one seeking affirmative relief from the court.
It seems like we might be confusing the words damage and injury. Your argument, the only evidence as to damages in that sense of the word was related to the wrist.
The only evidence presented as to damages would have been as to the wrist, and the jury...
Answer number one, that Duke was a legal cause of damage. If those were the only damages, how can they award a zero verdict? I mean, if the word said injury, that's something different, but it does say damage. If the jury said, well, the only monetary damages were related to the wrist, Duke was a legal cause of damage, how can they come up with zero?
I understand, Your Honor. I understand your position, and if the jury interpreted that the only damages would have been to the wrist injury, then that position would probably be correct.
Well, again, this is where the verdict form's not very clear. It could be physical damage, which would be scrapes and bruises and things like that, or it could be monetary damage. What did they mean by damage in this verdict form?
And non-economic damages as well, such as pain and suffering, et cetera, which they decided to give zero for all damages. So we submit, Your Honors, that Cowan versus Thornton and his progeny are all distinguishable from our case because we have other evidence presented to the jury, and the jury decided to...
Cowan had one injury, right? It was clear in Cowan. There was only one injury that was ever raised that there's any evidence about. So Cowan may not be quite the same as our facts.
Exactly, Your Honor. And that is our position, and as well as for the other cases that have been presented by the appellant in this matter. There's no factual scenario like ours. And in order to disturb or change the jury's verdict, there has to be some inadequacy of the verdict. And in this case, it is not inconsistent. The findings are not mutually exclusive, and that is the position that we are submitting, Your Honor. If the court is so inclined to believe that the plaintiff should be awarded some nominal damages, we would submit that additors should be the solution to this matter, limited to those nominal damages.
Just so we're clear, that wasn't argued below, correct?
That was not argued below. And again, for additor, there has to be, the court's conscience needs to be shocked. That is the standard, abuse of discretion, and that is not here. So we believe it doesn't apply. And to the extent that the court cannot distinguish Cowan or any of its progeny from the facts of this case, we understand that the solution would be neutral in its entirety, not only as to the issue of damages, as the appellant is submitting. However, we hereby request the court to affirm the verdict and the trial court's ruling. If there are no other questions, I think I've used my time. Thank you.
Thank you, counsel. Counsel, you have 5 minutes and 28 seconds.
I will see what I can do with that time. Thank you, Your Honor. First, I want to answer one thing that I was trying to recall before, and that was who that concurring judge was. And interestingly, it was the earlier Judge Harris, who in this court's decision in Simpson v. Stone, where it adopted Judge Altenburn's reasoned logic regarding the timeliness of the objection, said...
I haven't agreed with him for 50 years, so why would I start?
Fair enough, Your Honor, fair enough. But it is still there before the court that a timely preservation was simply something that this court mused then ought to have been done. It was in this case. And we just heard, Judge Harris's, the newer Judge Harris's question on the inconsistent verdict and how you can make these two sentences make sense together just from a grammar standpoint. And that's really why this is just a fundamentally inconsistent verdict, that you can't, without, changing definitions of what, if you have a legal cause of damage and we define damages as something that we award damages, that's money, not an injury, then some number needed to be put. And as Judge Eisnagel has pointed out, even if it's not Category 4, because that required medical proof, and there was certainly not any attempt to put medical proof of damage, medical proof of costs, of medical costs, or treatment for those scrapes and bruises that he received as a result of the negligence of the Duke employee as he pulled away. There absolutely was testimony that would support the some number being placed in Category 5. That didn't happen.
Was the jury instructed on that? Did they know they could give nominal damages? Did they know what nominal damages were?
I'm not sure. I have in a defamation case had a nominal damage instruction. But that's an infrequent creature that's not common for a personal injury case. Certainly, the plaintiff wasn't there seeking nominal damages. The defendant wasn't defending against nominal damages.
How would the jury even know what that was?
Well, and I'm not trying to say the jury did. In fact, I think that I'm going back to the elephant. The elephant is the jury was talking about the wrist. And the jury said, yes, you're a legal cause of that damage. And then how much is that worth? 0. And we can't make that make sense. And that's why we've got to send it back. I wish we could get into the DeLorean, go back and say, trial court, you've got the jury right there. Have them tell you what they mean. But that didn't happen.
Counselor, going back to the sort of definition of damage, I mean, under any definition of damage, it seems like the jury could have concluded the damage or the injury, however you sort of want to define it, was the bruising to the torso and the scrapes. And so, assuming that we don't think you preserved that, I mean, if we don't think you preserved that issue, arguing nominal damages for the bruises and scrapes, how does any definition of damage get you there?
Let me answer that question, and it's this: that the motion for new trial said we are entitled to damages. The inconsistent verdict said this verdict is inconsistent and you need the jury to fix it. No matter how we look at it, even if this court reasons, well, it could have been correct if the jury was thinking this instead of that. Now, I think Your Honor's already said the jury could have been thinking that. They could have been thinking the elephant instead of the flea.
We just don't know.
We don't know. So, for the purposes of this, if it were the flea, it's still an inconsistent verdict. His objection is correct that this verdict is inconsistent. Whether he says that it's inconsistent because of A or B, because imagine if the rule of this court is you have to, on the spot, think of every possibility that jury could have possibly done. Some cases have 12 injuries. Some cases have 1. You can't make the plaintiff's attorney verbalize the objection.
Is there another way to deal with that? Couldn't you have a more specific verdict form?
Again, you could, but both parties agreed on this verdict form. This is the bride that we took to the altar, and they're married to it.
Right.
And given that they're married to it, if you're going to have language that's going to say one thing in question 1 and another thing in question 5, you are inviting the jury to give its answers to those questions, and if those answers are consistent,
You're the one asking for the divorce.
it's true, Your Honor, but it's because the law requires a divorce here, or the law required counseling at that moment.
I mean, in essence, isn't it the appellant, whoever that is?
Sure.
Isn't it the appellant's job to get the verdict form right? If Duke Energy was the appellant here complaining about the verdict, wouldn't it be their job to have gotten it right?
But
Because the appellant has to demonstrate error.
here's the thing. Almost everyone agrees that the verdict form is right in that it's a legal verdict form that properly sets out what the jury can do. The jury could have answered these questions consistently. They just
And maybe
didn't.
they did.
Well, and if they did, then, well, if they did, they can't have, because there's no way to get to a 0 in question 5 with your check
Because
mark
of
in
nominal
question 1.
damages.
That's correct.
But I guess my point is that regardless of who the appellant is, if the plaintiff is the appellant, if the defendant is the appellant, whoever is trying to reverse the verdict
Sure.
has the burden. And so if there's vagueness in the verdict, that's going to cut against the appellant, whoever that is in any case, right?
As a general rule, perhaps, but the thing is, this verdict form, and Judge Altenberg bemoaned the fact that almost every case since 1997 when they changed the statute, actually 1991, most tort cases are now submitted to the jury with an interrogatory verdict form that usually causes a 0 verdict to be both inconsistent and inadequate. Judge Altenberg's prophecy was true here, but that doesn't change the fact that it's not a preservation issue by either side if they were confronted with it, as long as it's a legal and proper form.
But the appellee doesn't have to worry about preservation, counsel.
They don't, but neither does the
Only the
appellant. And the appellant always has to worry about preservation. But the verdict formation was not the issue whereby preservation either rose or fell in this case. Thank you for the additional time. Appreciate it, Your Honor.
Thank you, counsel. All right, we'll have a quick panel change.